Hello, everyone. Thanks for being here during this last session of CPDP 2021. I hope everyone had a nice conference experience. It's a bit special for everyone, but I kind of enjoyed parts of it. And so I'm glad that at least you guys are still here for this very last session, the academic junior session. Which is still really nice to have, because before I introduce the speakers, I do want to say that in the last couple of years, CPDP has gradually turned into this very big mega conference, if you will, with plenty of high-level panels and fancy talks by policymakers, even by big tech CEOs. But it's nice to see that the conference still keeps some connection, with its roots, this academic scholarship on privacy and data protection. And that is also why these academic sessions are always quite interesting. It really allows to learn more in depth about ongoing research and have more substantial discussions about it than often these panels allow. And this will certainly be possible in this session, as we have just two speakers for over an hour of discussion time. And in order to also kickstart these respective discussions, I also want to ask something from the speakers themselves. So it would be great if you could also each identify one or more things in each other's presentations that you agree with and or that you disagree with. That would be even nicer, actually. So this will also give the audience some time, to enter their questions into the chat. All right, so we have two great speakers. So first off, we'll start with Thomas Tombal. Thomas is a researcher at the CRIDS at the University of Namur, where he is writing a PhD on compulsory business-to-business data sharing, a tale of trade-offs. So his research really lies at the intersection of data protection, competition, and intellectual property law. And so today, right now, he will present a paper titled Data Protection and Competition Law, Friends or Foes Regarding Data Sharing. Thomas, the floor is yours.
Thank you, Jef, and thanks to the CPDP for giving me the chance to present some of my research. I don't know if you see my slides right now. Yes. Okay. Perfect. So yeah, I'm going to present like this paper, but it's very much still a work in progress. So I'd be happy to have comments also from people in the chat if they have some suggestions about some ways to go forward. Or so I'm really hoping for a discussion on this. And yeah, as the title said, it's going to be not purely data protection. It's going to be somewhere between data protection and competition law. So like some background, I mean, obviously I'm going to be very fast on this because it's probably something you hear every day if you specialize in these domains. But data really has a key role to play in our European digital economy. It's a key competitive asset, and because data is so important, we have more and more initiatives at the European level that push for more data sharing. But of course, when we talk about sharing data, a lot of this data, if not the biggest part of it, is often going to be personal data. So you come into questions linked to the GDPR, which as such does not prevent data sharing. The GDPR is really a tool about trying to find a balance between ensuring sufficient protection for the data subjects, but at the same time ensuring the free flow of data. So the starting point from the paper is a growing concern that is being voiced in the competition law community by competition law scholars, and it's the following concern that GDPR might actually increase concentration, might limit competition and increase data concentration. And there are classically three arguments to argue why this is the case. So the first one is, well, because big tech players have bigger pockets, and so it's easier for them to comply with these rules, while as smaller undertakings like SMEs some argue that the GDPR sometimes imposes disproportionate burdens on them. So, big tech players, it's easier for them to comply, or at least to put in place the compliance mechanism, or they have bigger pockets, and so that helps them. The second argument, and it's mostly on this one that I will focus in the context of this paper, is that actually the GDPR, which allegedly was potentially adopted as an instrument to kind of regulate the practices of these big tech players such as Facebook and Google, well, this very instrument that was adopted to kind of restrain what they do is actually being used by these players to refuse sharing data with third parties. And I mean, we can discuss on whether this is legitimate or not, and very often it's going to be a case-specific answer. And I mean, they use that to prevent data sharing with third parties, and arguably this restrains competition. And the third point is that according to some authors, and I think about here a paper written by Condorelli and Padilla, that these big players, they engage into what they call envelopment strategies through privacy policy tying. So in a nutshell, is the idea that, to use one of their service, you have to agree to one of their privacy policies, but actually by agreeing to that privacy policy, you kind of get thrown into a bigger ecosystem than is just more than this specific service that you're agreeing to use. I mean, when you want to register to Facebook, I mean, you don't just the privacy policy often is not just going to be about Facebook. It's going to be also about using data from third-party apps. It's going to be using data from other members of the Facebook group. And I mean, this led to like the German Bundeskartellamt case that I will come back to later. And so these are kind of the three concerns that, using data protection considerations, these big techs are reinforcing their position on the data markets. And so where does this, so the way I read this is that basically this critique coming from the competition law field relies, as I understand it, on a double premise. So the first premise is that GDPR is more lenient towards personal data reuse within the ecosystem of these large data holders than it is towards data sharing with third parties. And the second premise is that the way these large data holders actually reuse the data within their own ecosystem complies with data protection law. And one of the main points of the paper is to actually, reflect on these premises and to say, well, aren't they challengeable? So regarding the first premise, I mean, one way to challenge it is to say, well, if you take data that is used for purpose number one, because of the purpose limitation principle, if you're going to reuse it for purpose number two, at the end of the day, it doesn't really make a difference, and it shouldn't make a difference whether it's external, it's reused by a third party, or it's reused within your own ecosystem, because, I mean, if that second use is not compatible with the first one, you're going to need a new lawful basis, etc. So the purpose limitation applies in the same way in both scenarios. And I mean, when you look at the practices and the privacy policies of these big players, I mean, it can be questioned whether the vague purposes that are sometimes used to kind of justify this internal data free-for-all, as it's called by Géraldin and others, is, they talk about providing our services, improving our services, developing new services, but, are these purposes really framed in a way that is compatible with purpose limitation? And I mean, this wide framing explains why this data is kind of reused all through the ecosystem, but we can question whether from a purpose limitation perspective, it makes sense. They rely a lot on consent to do all of this, but I mean, we can also discuss on, whether the quality of consent obtained from data subjects, whether consent is specific enough, because often it's going to be kind of bulk consents that justify the circulation. And finally, I mean, in terms of data minimization, so even if a big tech player has collected a lot of data for purpose one, that doesn't mean that it can reuse all of this data for purpose two, even internally. I mean, they would only be able to reuse the data that is necessary for this other purpose internally, etc. So I mean, from a purely theoretical point of view, that it shouldn't be easier to circulate data internally than to share it with third parties, because the same principles apply. The second premise, and I'm going to spend much more time on this one, is to say, well, they actually comply with data protection. And where does this premise come from? It comes from kind of three elements. The first one, and it's linked to something I said before, is that they have more means to comply. So we assume that because they have bigger pockets, it's going to be easier for them to comply than for small SMEs. So that's the first point. The second point is to say, well, they are so big that, of course, the data protection authorities are watching them. So because they have an increased scrutiny on them, they have to be respectful, right? So that's the second part of this premise. And the third part of the premise is to say, well, their whole business model relies on data processing. So if they are found to be in breach of data protection rules, then the whole business is going to collapse, basically. So they cannot afford to not be compliant. So I'll focus mostly on the second one here, but I mean the first one, there is some truth to it. So the fact that they have bigger pockets, so that it's easier normally for them to comply. The third one, I mean, we can really think about it, because when you look at the Facebook Cambridge Analytica scandal, I mean, at the end of the day, Facebook didn't lose that many users after that. And you could say allegedly because, there's nowhere else to go, simply. So because there's nowhere else to go, maybe they're not so afraid of data protection scandals, and maybe they're not so afraid of data protection authorities. I think the recent case with WhatsApp is a little bit more interesting, because there was kind of a response from the people, like considering going more towards apps like Signal, etc. But here, what's really going to be interesting to see is like the network effect, because I mean, okay, I consider myself as being rather like sensitive to all these data protection issues. So I mean, I kind of talked about it with my friends group on WhatsApp. But I mean, if we are a group of 20 people and only 5 of us move to Signal, I mean, I'm going to keep WhatsApp because I still want to keep talking with the other 20. So the network effects might have an impact on this as well. But focusing today on this increased supervision by data protection authorities, I mean, we can really, for sure, there are issues with the way these big players process some of our data. I mean, I talked about it a little bit earlier in terms of purpose limitation, data minimization, transparency, consent, the validity of the consent they collect. I mean, I'm not going to talk about all the decisions, but I mean, there's been a decision by the Irish DPC recently against Twitter. There's been decisions by the Swedish and the Belgian data protection authorities against Google for breaches of the right to erasure. And there's, of course, the famous cases by the CNIL in France, so the French Data Protection Authority against Google. So the first one where they were fined 50 million for a lack of transparency and a lack of valid consent. And then more recently, the double cases against Google and Amazon for the use of unlawful cookies or unlawful cookie practices. So, I mean, there is a control by data protection authorities, and the behavior of these companies is sanctioned. But at the end of the day, when you look at these fines, I mean, the biggest is a 100 million euro fine by Google on Google. I mean, if you compare that to their market capitalization, to the annual turnover, I mean, it's nothing. And I mean, this has been a practice that has been going on for years, and it hasn't, even if they get sanctioned, it doesn't really change much. So you kind of have a sense of impunity, I think, that can develop in these big techs. Not that the fact that they're not going to be sanctioned, but I mean, even if they get sanctioned, at the end of the day, it's not going to be that terrible. And this is where it gets tricky in our link with competition law, because this not only leads to a privacy issue for the users of these services, but it also leads to a competition issue, because these big players have acquired very strong market positions, allegedly or not. I mean, this is open to discussion, not only based on the value of the services that they offer, which, I mean, I'm not here to critique the fact that they offer great value in their services, but the question is it just this? Like, is it just legitimate competition, or did they manage to get there also as well there through through privacy dubious practices, and that now makes it very hard for a third party to compete with them, because if a third party wants to be GDPR compliant, it's going to be very hard for it to contest the position of these big players. And to a certain extent, competition law and competition law authorities themselves had a role to play in this. And in the way that when you look at merger cases, so for example, the Google DoubleClick merger, the Facebook WhatsApp merger, the Microsoft LinkedIn merger, or the ASNEF Equifax case of the European Court of Justice, in all of these cases, basically what the competition authority was saying is like, okay, any competition issue that you deem linked to data protection or any data protection issues is not from our resort, because there are data protection authorities that are there to enforce data protection laws. So data protection is not a competition problem. So we're going to consider that what they do is respectful of privacy, because otherwise it's going to be enforced by data protection authorities. So we kind of turn a blind eye on that. So you have a vicious circle, because privacy authorities, I mean, yes, they do act, but we can discuss on whether this enforcement is effective enough. And that has an impact on competition, but competition authorities do not act because they assume that privacy authorities act enough. And, you kind of have this vicious circle that works around. So one of the few exceptional cases in this regard is the German case that I mentioned earlier. So the Bundeskartellamt case against Facebook, where there essentially the Bundeskartellamt, so the German competition authority, ruled in preliminary ruling that Facebook was abusing its dominant position on the German social media market, because its users, in order to use Facebook, you had to consent to the collection by Facebook of data from third-party websites and from other websites from its ecosystem, so Instagram, WhatsApp, and you had to consent to these data being collected and combined to draw profiles from you. So here, interestingly, the German competition authority said that this constitutes an exploitative abuse, which is something that is very rarely prosecuted. I mean, competition law, most often, so the 102 case, so the abuse of dominant case, is mostly going to be about exclusionary abuse, so the fact that you exclude competitors from the market, but rarely about exploitation abuse on kind of the, in this case, the users of these practices. But this case is kind of a pioneering case, and it's still quite uncertain how it's going to work out, because, I mean, it was appealed by Facebook to the Düsseldorf regional court, which overturned the decision, saying that the competition authority failed to demonstrate a competitive harm. This was overturned once again, so the federal court in Germany came back on the decision of the appeal court, so essentially validating the reasoning from the competition authority. So now it's back to the Düsseldorf court, so we'll see what happens. But so what I want to show at this point is that, I mean, this double premise on which competition, there are growing concerns in competition law that, these GDPR is helping big techs, they are challengeable. So this is the point I want to make at this point, is that they are challengeable, like we can really discuss about it. But in practice, we have to admit that they do still apply double standards in practice. So these big players apply very restrictive approaches towards data sharing with third parties, while they massively reuse data within their own ecosystem. So basically, they apply to others standards that they don't apply to themselves. And the question is, why is this a problem? And how did we get there? So mostly, I would say that it's a problem of enforcement. So it's not so much a problem of the rules. I mean, the rules are there, and we shouldn't be in a situation like this. But GDPR is still, a recent tool. I mean, it entered into force in May 2018, so it's still in its first days. But we need stronger enforcement, and this is one of the major problems. We need stronger enforcement. And in order to have stronger, better enforcement, we need more means for these data protection authorities. I mean, when you look at the funds that these data protection authorities have, when you look at the staff that they have, I mean, with all the goodwill in the world, it's very complicated to go against huge giants who know how their own system works and who have so much more money and staff than you. And so that's a big the first issue. And then the second issue, and I don't want to enter too much into this detail, into this debate, but I have to mention it, is the whole question of the one-stop shop provision in the GDPR, and the consequence that most of these cases have to end up in front of the Irish DPA. And I mean, this creates also problem for this Irish DPA, because it's going to concentrate a lot of big, massive cases, and it still has a limited staff. So just to give you an idea, its budget is 17 million euros a year. It's the 6th budget in Europe, which, I mean, we could really be thinking, well, shouldn't it be the first, knowing that they have in their under their supervision like huge players like Facebook and Google. So this whole enforcement issue makes it very complicated, and that's one way we have to go. So I mean, we could start to rethink about the data protection, about this one-stop shop. Do we want to make some changes there? I think at this point, the first change that we need to make is to ensure that all these data protection authorities have the sufficient means to actually get to work and to enforce. So, I mean, as a conclusion, I would say that like the only way to go about this is really that we have a crucial need for more enforcement. So we need more enforcement against these big players. And it was interesting in the decision that was given by the Belgian Data Protection Authority against Google. It was a case about the right to erasure, and at the end of the day, the fine wasn't that huge. It was 600,000 euros. But in that decision, they said that these big players have a special responsibility in applying the GDPR and ensuring that they are compliant with this. And I mean, this is a sentence that the Commission has repeated often. I know with great power comes great responsibility. So I think we need to have more enforcement, and we need to have more targeted enforcement against these big players. We might need to consider maybe other types of remedies, not just fines, but maybe remedies that go a little bit further than that. And in that case, the Bundeskampfland case is interesting, because there one of the remedies that was proposed was actually a data siloing. So the idea that Facebook cannot circulate this data internally as easily as they're doing now. And quite interestingly, when you look at the DMA, so the Digital Markets Act proposal, there is like a provision that, the way I read it, it could be understood as imposing some forms of data siloing for these gatekeepers. Which, I mean, to me, it doesn't really make it. There's no way to doubt that Google and Facebook clearly fall within the definition of gatekeepers given in the Digital Markets Act. And I mean, if not, then we have a problem with the definition, because I'm pretty sure that the Commission wants those two players to fall in there. So yeah, so we might need to consider other ways to make data protection enforcement stronger, because if we have better data protection enforcement, then it should also entail more competition, because if you have stronger data protection enforcement, then you can start having more competition from a privacy perspective. Privacy and data and the respect of the user's rights can become a competitive argument to be brought forward, and you could have development of competitors going there. So it's kind of the idea, like, when you look at in my title, like, are they friends or foes regarding data sharing? Or I would say that right now they're foes regarding each other, because we have this vicious circle between lack of enforcement and data protection, which leads to lack of competition. We need to reverse this cycle to a virtuous cycle. So the idea that we have more data protection leading to more competition, leading to more data protection, etc. So that's the first limb. And then the second limb is we have to address the other side of the double standards, which is to say we have to be really more critique when analyzing the argument made by these big platforms to say, well, I refuse to share data because of the GDPR. I mean, clearly the GDPR is not there to prevent all types of data sharing. I mean, the UK ICO released, I think at the end of December, beginning of January, I don't remember exactly now, guidelines on how to do data sharing that is compliant with the GDPR. So I mean, the GDPR as such doesn't prevent data sharing. So we have to have a bigger scrutiny on these on this argument made by the data protection by this big player. So it's really a double-headed plan. Like, there's a need for more data protection enforcement. There's a need for bigger check on this aspect, and hopefully this is one way to try to address this double standard. So I'll leave it there for now. I mean, of course, the paper goes into more details on some of the aspects, but I think in 20 minutes I gave you the essence of it, and I'm really looking forward, as I said, to discuss this with you and to have your comments on this. Thank you.
Great, thanks a lot, Thomas, for that nice presentation. And I want to open the floor for questions. I see there's no questions yet, but so perhaps I can ask Cemre if he has a question already, something that he might vigorously disagree with, so we can have a fiery discussion. That would be nice. But of course, you can also just say how much you like the presentation.
First of all, thank you very much, Thomas, for this very interesting presentation. And I have to say that I'm not an expert in competition law, but I find it really interesting to learn more about competition law. And in your presentation, you said that for giants, it's relatively easier to comply, which I agree. And they refuse to share the data with third parties, which restricts competition, which I also understand. And third parties, for example, on Google, on Facebook, they are built. And one part of your presentation really grasped my attention, which is about the place where you mentioned consent. So if it is necessary for the app or for the platform, let's say on Facebook, it's possible to have these third parties. And then you say Facebook, in a way, circumvent a consent by indicating that it's necessary, right? So if I understood correctly. So I'm not sure how this relates to the competition law restriction when you have the consent through to cover the third parties as well. And you mentioned the German case. Mm-hmm. It's an abuse, but then how will this affect actually the third-party apps on this giant Facebook or Google? So in order to have, let's say, a YouTube account, I need to have Gmail, and how this latest German law case be interpreted, and how will it actually change the practice? Thank you very much.
Yeah, thanks. Thanks for the question. So yeah, so the point in the German case is to say, well, you know, basically because Facebook is in such a dominant position, it can impose conditions on its users and abuse overexploit, if you want, its users, in the sense that it's going to be able to collect more data than it should. So it's really here the argument that, you know, I shouldn't be forced, if I want to be on Facebook, to accept that it's going to also use data from Instagram and WhatsApp and from, so the third-party websites in question, it's, you know, all these websites where I can, if I'm reading an article on a journal website and I can like with Facebook, you know, then they want to reuse that data as well to their website. So, I mean, the thing is, I kind of have to agree with this if I want to use Facebook. So that's the whole point that the German court is trying to make, is that to say, well, they're exploiting me, they're extracting more data out of me than they should. So, I mean, it's a complicated case because, you know, to make it simple, it's kind of the idea that they make me pay more than I should pay normally, but because I don't have a competitor, a valuable competitor on the side where I can pay less. So that's the complex case. So what this means for third parties, I mean, so it's complicated because if I want to develop a personalized social network, but that I don't force people to give me data that comes from other sources, I'm never going to have as much data as that big player. And so my service is never going to be as personalized, and it's never going to be as, you know, user friendly in a way. So that's what makes it very complicated. And this is essentially what the Bundeskartellamt said, is that no other company can impose these kind of conditions, because people would just not sign them. They would just go somewhere else. So I mean, I don't know if that fully answers your question.
Yeah. For example, if you don't like Facebook, where else you could go then, right?
Well, yeah, that's. But I mean, that's what, as I said, I'm very curious to see what's going to happen with this Messenger and this WhatsApp Signal issue. I'm just a little on that case. So I'm a little bit surprised that it makes so much noise now, and that it didn't make noise a couple of years ago when Facebook actually got fined by the European Commission, because in the Facebook WhatsApp merger case, one of the commitments that was made by Facebook was to say, okay, we're not going to take some data from WhatsApp to put in to like match with Facebook users, and that was one of the conditions upon which the Commission accepted the merger. And then it occurred that I think less than a year later, the Commission found out that actually they were sharing data, so they were fined for this. But back in the day, that didn't make so much of a like public outcry. I mean, I guess it's good that it's happening now, but I don't know what effect this is going to have in practice. I don't know if people are actually going to move. So we'll see.
We have two questions from the audience. I'll just read the first one from Paddy Learson. A question that I'm not sure I understand entirely myself, but hopefully you will, Thomas.
Okay.
So basically, Paddy asks, doesn't the idea of a market for privacy fail due to information asymmetries? For example, the market for lemons argument.
Okay. Yeah, I see the point. So the idea that, I mean, the way I understand the question is to say, well, can we really have a market for privacy, which would imply that people read all the terms and conditions and understand, and also information asymmetry in the sense that I understand the tricky part is to say, well, I could always say as a company that I'm more privacy compliant than Facebook, but because me as a consumer, I don't see how the service works internally in terms of information. There's an information asymmetry there, because I'm not really able to check whether what they claim is true or not. So I mean, yes, I think that's a risk. I'm hoping that if this is linked to more enforcement, that there will be enforcement against such false claims, and that if we have strong enforcement from data protection authorities, this gives good signals to the users, because they cannot by themselves check the internal process. I mean, that's not realistic. So it is a danger. It is a danger, but I think trying is still better than what we have now. So I mean, we have to go forward. And I mean, I cite Facebook and Google a lot here because, of course, I mean, they're the two clear examples. But I mean, I also understand that it mustn't be. I guess it's not so easy to be 100% privacy compliant when you have such huge services. So I'm not saying that it should be like just a snap of a finger. It's easy to do it, but I think there's really a lot of room for improvement. And I think where it gets problematic is when you tie this link with competition, and the fact that to some extent there are also the way they exploit the data makes it that it's impossible or very complicated for other parties to emerge. So it kind of protects the current situation. So I mean, we need clearly we're in a vicious circle right now, and I think we need to get out of it. And there is going to be uncertainty on whether this is going to work. I mean, I don't even know if the majority of the people want more privacy-friendly apps, because I mean, of course, if you talk about this at the CPDP with a lot of privacy-savvy people, I mean, it's obvious for all of us that we want something different. But I mean, I'm not so sure that's necessarily the case for everyone. I mean, it's the whole privacy paradox, and how I think another problem that I didn't touch on here is, like, how do you give the information to people that you are more privacy compliant? Because I mean, people don't read privacy policies. So how, if people don't read, how can you don't take the time to read it? How can you demonstrate that you're more compliant than others? So, I mean, maybe there's a role for some form of certification from the commission or something, or from the EDPB or from data protection authorities that kind of would certify that some services are more privacy compliant than others.
Sure.
But
I do have some thoughts on that as well, but I do, like, in light of time, I just want to squeeze in perhaps one more question from Athena Christofi, but please keep your answer short. So basically, Athena asks, first congratulates you with a great presentation. And then she says basically that the GDPR doesn't preclude legal sharing, as you also say, but companies would need a legal ground, of course, to share that personal data. And Athena says that among the lawful grounds in Article 6, she thinks the most feasible one would be legal obligation, especially in light of that they wouldn't have much incentives to share data in the first place. And so building on that, she asks, do you know if there are any legislative initiatives happening on this already? I'm thinking of the recent ones in December launched by the Commission, of course, but maybe you can give some thoughts.
But just so you would have legal obligation as the lawful basis of the processing because I mean, when you talk about a transfer between, let's say, the big tech and the reuser, the big tech needs a lawful basis to send the data, and yeah, I mean, there we can rely on these legal obligations that are going to be there in the Digital Markets Act and things like that. But then, I mean, the data recipient itself also needs a lawful basis, and there I'm not sure the legal obligation would be it, because I mean, the legal obligation is you, big player, you have to share it with that person, but that person doesn't necessarily have is not necessarily entitled to use all of the data based on this. So I think there it's going to be complicated. I mean, there the lawful basis is probably going to be more either consent or maybe sometimes a legitimate interest, but that might create issues in terms of transparency. So I'm not sure that for example, having in a provision in the Digital Market Act saying Facebook has to share some of its data with well, Facebook is maybe not the best example, but for example, Amazon has to share some of its data with the sellers on Amazon. Like, I'm not so sure that might suffice as a lawful basis for the users, but that's something that I haven't quite dug in much further at this point.
All right, thanks. And maybe Athena can follow up.
Yeah, I'd be happy
on that question. But okay, in light of time, we'll jump to the next speaker now. Who's and I hope I'm not butchering your name again. Cemre Bedir.
Yeah.
Yes, who is a PhD researcher at Tilburg University. He has a background as a legal practitioner in Turkey, and his research centers around consumer contracts in the tech sector. And that's also the topic of the paper that he will present today. So basically, contract law in the age of big data. Cemre, take it away.
Yeah, thank you very much. So hello everyone again. It's amazing to be here, even virtually. And I would like to thank the organizers for organizing this very successful conference and their efforts to make it happen. Also for the reviewers for their feedback. It's all about feedback. We receive feedback, we give feedback to make the world a better place to live with data protection, of course. So my name is Cemre Bedir. I'm a PhD researcher and in the Netherlands. So now I'm in the third year of my PhD and focusing on data protection and specific contract law. So this presentation is based on my paper, which concerns the main research question of my thesis, which is what sorts of legal problems can arise from contracts that involve personal data, and whether we can map and solve these questions through certain specific contracts within English and German law. So yeah, we live in the digital age, and as we know, everything that we do creates data, and every purchase you made, every picture you take, even every heartbeat can be digitized and tracked. And the use of the internet is not a choice for many people. So I don't think there's any job exists that can let you refuse the use of Google for your privacy concerns. To be a functioning member of a working society, it is almost necessary to have a LinkedIn account. And in these business models, consumers don't pay a price, but provide their personal data in order to benefit from digital content and services. So then what is the problem? So data-driven technologies are so advanced and often don't fit into existing legal categories or concepts, such as the legal concepts of ownership in a copy of software instead of a physical medium, or tradability of personal data. So here we need to take into account contract law. Why? Because contracts naturally facilitate interaction between companies and users. And contract law concerns the economic ordering of the society and develops in line with this order. As personal data has value and this value is exchanged for the digital content or service, contract law must examine these transactions. And data is most of the time collected and processed through a contractual relationship. Therefore, we need to take contract law into account. And my research question is whether we can use contract law to map and realize the aim of the GDPR. And I will focus on specific contract law, but there are certain regulations and directives to keep in mind. And the most important ones for my research are the GDPR and Digital Content Directive. And before I analyze contractual challenges, I will briefly talk about data protection law. So we have the GDPR, which is a regulation. We find all rules regarding the data protection and processing personal data. And what is personal data? Any information relating to identified or identifiable natural person. So this can be your name, location, even the name of your favorite team. And in my case, Galatasaray, which is the best Turkish football team, by the way. And when we look at the definition of processing, we see that it means any operation that's happening on your personal data. And the principles of fair and transparent processing require that the data subject to be informed of the existence of the processing operation and its purposes. So also, whatever happens with the personal data, you need to have a certain legal ground. This can be the consent of the data subject, which means we as individuals grant consent to the collection and processing, or the execution of the contract makes it necessary to collect personal data, or there has to be some sort of legal obligations that we just mentioned. But in practice, consent constitutes the legal grounds most of the time, and it is problematic, and I will focus on why and how. So when we look at the definition of consent in the GDPR, we see that there are 5 separate elements which need to be respected in order to talk about valid consent. And these requirements are difficult, and I will explain it under contractual law issues. So this was very briefly GDPR part, and now the Content Directive, which is one of the specific contracts that plays a significant role. And secondly, it is also part of the solutions. So digital content and digital services are often supplied where the consumer doesn't pay a price, but provides personal data. And this directive aims to ensure that consumers, in the context of data-driven business models, they are entitled to contractual remedies. So I will just keep it this short because I will focus on more contractual issues. So when we come to the contract law field, we see that there are certain problems. When we briefly look at, for example, the functions of money, we see that we can see that it's a medium of exchange, measure of value, and store of value. So can we say the same about personal data? So the brief answer is yes, but it comes with certain questions. Why? It is difficult to argue that consumers experience an economic loss by providing their personal data, as the provision of the personal data doesn't usually prevent the individual from providing the same data to another provider. And also about certainty. So one of the conditions to have a valid contract, there should be an object, and it should be determined, or it should be possible to determine. When you enter into a contractual relationship, you will wonder what the other party's counter performance is going to be. Because the other contractor cannot measure your counter performance, how can it be used as a currency? Similarly, in cases where the value of the performance or performance itself is vague or ambiguous, it will be difficult to establish whether there is a valid contract in the first place. You may even discuss here whether it constitutes consideration, for example, under English law. If there's no consideration, then the contract cannot be enforced. And secondly, the calculation of the value is also a problem. How is it going to be calculated? Data becomes meaningful when it falls within the combination of big data, from which you can actually conclude results most of the time. And another issue is about ownership, but I want to discuss the ownership issue in this research, as there are already PhDs about the ownership of personal data and problems thereof. But we know that data is an asset, and there are two questions mainly. Can we trade, and should we trade? So when we talk about trade, we always assume that we own things. So this applies to a car or even a pen. The ownership is recognized by the law, or put it differently, I owe something because the law says so. In many civil law traditions, for mobile goods, if I possess something, the law presumes that it belongs to me. Therefore, I can sell or trade it. So I may sell this pen that I got from our secretary, actually, to use during my research. I can control what's going to happen to this pen as long as my department allows me to do so. But there is no such treatment when it comes to data, including personal data. In the Digital Content Directive, for the first time, we see that personal data, is an element of a contract. And there is an indirect recognition of ownership right over the personal data. So what I'm going to state only here is that Facebook states that, let's say, you are the owner of the picture that you share on your profile. But some other third parties can also control and process the picture. And when you delete the picture as an owner, Facebook deletes it from the storage. But is it possible to have these third parties to delete the picture as well? So I think control in the digital age becomes more important than the ownership. So this issue also has a fundamental right aspect. So on the one hand, you enter into a contractual relationship which obliges you to provide your personal data. And on the other hand, it's your fundamental right, and you can withdraw your consent for its use. And in theory, you have the right to stop the process. But if this becomes a currency, how will this work? So the example here is given usually the market for live human organs. Just because there is a commercial transaction involving personal data, the fundamental right protection shouldn't be excluded from its application. So when we look at Article 7, Paragraph 3 of the GDPR, we see that it gives the right to the data subject to withdraw his or her consent at any moment, which makes it tricky. Why? Because contract obliges him to continue supplying the data. So we have two issues here. The first, it is unclear whether the provision of personal data in violation of data protection law may still qualify as counter-performance under general contract law. And second question, whether contracts operating with such unlawful transfers fall under the scope of the Digital Content Directive. And in order to talk, let's move back to the contract law again. And in order to talk about contract, we basically need an agreement and the intention to be legally bound and under common law jurisdictions consideration. But if you don't know the scope of your consent, does it constitute an acceptance? Is there a contract in the first place? If you argue that there is no contract, but you are already provided your data, then what is the legal status of it? Because you still provide your personal data, which has a monetary value, but you don't give consent for the further uses, then is it consentless consideration? So also, after the contract is made, there can be certain instances where the purpose of contract changes, and the apparent situation can become something that the parties, or at least one of the parties, wouldn't have granted consent to it in the first place. So although the consent that the parties grant is static, the practice itself calls for, in a way, a sort of dynamic consent, which can serve the purpose of the parties in a better way. Otherwise, chances are the practice is de facto against the consent of one of the parties, which therefore will question the validity of the contract. And the other issue, the third issue, is about termination. So individuals are granted with the right to withdraw their consent at any time, and in contractual terms, this can mean termination for the future. But is it possible to partially terminate the contract? How to comply with the result of termination? On the one hand, you as an individual, you don't get the content anymore, but the third parties are still making money out of your data. What can contract law offer here? When we look at the general contract law, we see that we have the remedy, which is specific performance, in order to receive the data back from those third parties who are involved in the collection and the processing procedures. So now, when we come to the field of solution, I'm using specific contracts as a tool. In my research, I've chosen 5 different specific contracts: consumer sales, medical treatment, processing, storage, and digital content contracts. Why these contracts? Because when we look at, for example, in medical treatment contracts, for instance, which interact with public law regulation and fundamental rights, patients are allowed to retract their consent in every stage of the medical treatment because it's a fundamental right. Unlike contracts in which personal data is processed, the patient is informed about all the stages of the treatment and observes the treatment, which makes it easy for the patient to retract. Also, data is a commodity, and to handle this commodity, I'm currently focusing on the storage and processing contracts, and concerning adjusting the contract for the later developments, service contracts can be used. And when it comes to mandatory and default rules, I will use consumer sales contracts. But at this stage of my research, I can give you only certain basic examples as I'm still developing this research. For instance, when the contract is terminated by one of the parties, most of the time, the digital content or service provider cannot guarantee or cannot prevent others from using the personal data that is subject to the contract. So in these kind of cases, in German law, section 346, paragraph 2 of the BGB, German Civil Code, it provides solutions as the creditor, in such a case, is allowed to provide monetary compensation for the value of personal data with the data subject. So this can be used. And similar to medical treatment practice, sorry, can we go back to previous slide? Because I think I didn't mention all of them. So similar to medical treatment practice, the data subject should also be allowed to ask individual questions to data controller before the conclusion of the contract, which can also serve the purpose of establishing the informed consent of the data subject. So audio-visual presentations in the medical treatment field are the most efficient methods that when it comes to establishing informed consent. Therefore, instead of providing the data subject with written text, the use of multimedia, where audio-visual slides present how the personal data processing is taking place, can be actually more effective in promoting the immediate recall of the information concerning informed consent. And under storage contracts, the warehouse keeper is entitled to change the terms of the contract in order to change the agreed type of storage, if the warehouse keeper can assume that the depositor would approve such change if the circumstance is known to the depositor. So this is the rule. And this rule can be applied to the contract where personal data is stored. This requires that service provider must provide another type of storage for the data subject in cases when all security measures that the service provider take in the storage fail. Also, where it's possible to define a part of the service or content that is provided in return for the processing of personal data, the data subject then can have the right to terminate the contract only partially. So in this study, I made the analysis by taking two main arguments into account. So these are, whenever data is collected and processed, contract law applies, and when problems relating to the GDPR arise from those contracts, contract law can still function as a potential solution mechanism to map these issues, and provide certain solutions. So consent comes with a cost, as there are technical and legal ambiguities when it comes to its scope, and the observation of data flow and control of personal data seem to be challenging to follow by the data subject. And the requirement of consent in the GDPR needs to be more elaborated and cover the data subject's further consent. Data subjects generally give blank consent, and this blank consent doesn't have all the details of long-term consequences, which is something contract law can provide. Consent actually doesn't cover the spectrum of what's happening with the personal data at stake and what businesses want to use the data for. So in other words, here the GDPR is still somewhat ineffective. Secondly, the control of data can be more important than the ownership of the personal data. In fact, when the control of data is lost, the contractual relationship will not work either. So this is not well clarified in the GDPR. Also, the traditional applications of contractual concepts of termination to the contracts that are made in return for the data also raises questions regarding both contractual remedies and consequences. So in this context, what needs to be examined is the connection between data protection law, rules that are applicable to digital content and services, and contract law. So I'm now curious about one issue. As having so many privacy lawyers here, I'm curious whether privacy law itself actually can offer any solutions or guidelines to the problems that I described. Thank you very much for your attention, and I'm looking forward to hearing your comments.
Thanks a lot for that presentation. I mean, as a data protection lawyer myself, I cannot resist already making one brief comment, and that is, please make a distinction between privacy and data protection. Conceptually, it will help you also in your research question, I think. But I want to give the floor now to Thomas. Hopefully, he has also some nice questions or comments to trigger a discussion.
Yes, thanks, Jeff. Thanks, Cemre, for the presentation. I thought it was quite interesting to kind of have a different look and have a look at how, the data protection and contract law can intertwine, and what are potentially the issues there. So I have two questions, remarks. I mean, however you want to call them. So the first one is on data as currency. I agree with you that data ownership is not the relevant debate to have here, right? And I mean, I think the debate has moved past that, and the idea of having ownership on data were more in terms of control and access, which I think reflects the situation today. But like you mentioned in the three elements of data as currency, the issue around certainty of the value. I'm not so sure there's there's an issue about the fact that there's value in such. Like, I mean, if I think about my the contract I have with Facebook, I mean, to me, it's pretty clear that there's value for both players. I mean, there's value for me because I get a social network out of it where I can interact with my friends, etc. And there's value for Facebook because it's going to get my data, which is going to help it to fund its advertisement, ad-based business model. So the issue is not so much, I think, whether there is value or not, because I think there's pretty clear that there is. I think where it becomes complicated is in the issue of calculating that value, and that's maybe the first question is, what are your thoughts on these increasing propositions of saying, well, we're going to pay you for your data, like these kind of alternative social networks where they say we're going to pay you for the data. But to me, this it's very complicated actually to value how much the data about Tombal is worth, because actually my data, maybe the data about Tombal is worth nothing. I mean, what's worth the value in my data comes from my social graph, the combination with data from others, from my friends, with whom I share interests, etc. So I think it's very complicated to evaluate the value of data pertaining to one specific individual. You kind of have to see it a bit more. So I was more, the first point is maybe on having your point towards like this, data as currency, okay, but like how do we assess this value? And also, I understand like the debate with the data protection is a fundamental right, and I shouldn't be able to sell my data. And often we make the comparison with the organs, that I can't sell my organs, but I mean a very big difference is that organs are I mean, I only have one heart, but I can give my personal data to 25 people differently. So I think maybe that plays a role in itself. And I mean, in practice, data is sold, or I mean, however you want to call it. So I still think it's important to address that. So that's maybe the first question, is like, how on this whole valuation, like how do you think we should go about valuing the data from the users? And the second point is more a general question about the work and the paper is, what is for you the advantage of resorting to contractual law rather than data protection law on all of these issues? Like, what's the added value that we get from contract law that we wouldn't get? I mean, I'm thinking in terms of termination of the contract. Like if we assume that I don't give my consent anymore, well, I mean, then the data controller doesn't have a lawful basis to process my data anymore, so normally he has to delete it. So, I mean, what does contract law give me extra to data protection law? So that's maybe my second broader question.
Thank you very much. These very interesting questions, actually. These are the questions, actually, I'm also still exploring myself. And when it comes to this certainty and value, actually, so when we look at the provision under German law, we see that this alternative is if you don't have the control over something that you have contracted, then as a compensation, a payment can be done. But how to assess the value of each person's personal data and then make the payment? When WhatsApp and Facebook actually merged, there was a payment on each person on WhatsApp, actually. So it was something about $90 or something was paid for each user. So maybe this is something technical that I am not 100% sure, but if there is like ways of calculating this value, then it can be used. So this is how I would think about this first. And second, so why contract law, why not data protection law? So this was one of the questions when I also asked myself when I started to read more about specific contracts, especially certain contracts like service contracts and medical treatment contracts. So what's happening with in this digital age is that you contract over your personal data, and we have an asset over here, and this asset is a part of a contract, and you receive something in return as a service. And when we look at the contract law, there's already certain mechanisms which work well for certain objects, not personal data maybe per se, but certain other objects which can also be used as tools. For example, when I talk about this static consent and the comparison of dynamic consent, we see that in the medical treatment field, there is already use of, in the biobanking research, this dynamic consent is already being used, which can also be used in the data protection field. Another example that I saw that when I was starting this project is that, for example, in the service contracts, when you have a car and you want to have it repaired, you leave the car in the mechanic, and the only agreement is that he or she is going to fix it for you. But then during this procedure, this car actually is being driven by the mechanic, also taken to another place to complete the contract or fulfill or enforce the contractual obligation. So I see these kind of similarities with the data protection and in these big social media platforms. So when you leave your personal data away just for the benefit of having the digital content or service from, let's say, from Facebook, you in a way accept that some third-party apps will also have these kinds of extra users. But how to find a balance and how this traditional contract law actually deal with these problems, this is what I find fascinating. To maybe there's a way to apply in practice in the in these problems that I described, but still I'm not in that part of the research to see how in practice how it would be relevant actually. But I will think about it. Yeah. Thank you.
Great, thanks. We have a question in the chat from Cesar Augusto Fontanillo Lopez. Fantastic name. First of all, he compliments you on an excellent research topic, and then asks to what extent you differentiate between data provided by the data subject for the purposes of concluding an agreement, and in situations where data is not the purpose of the agreement. So specifically in clinical trials where data is indeed the purpose of the agreement. So in the second case, where it's not the very purpose of the agreement, the withdrawal of consent would further make the contract ineffective. What do you think about it?
Excellent question, actually. This is a question that I was thinking after I published this article. I was thinking maybe I should add this part to the article as well. So let's say when you enter into a contractual relationship and you only provide some personal data, which is necessary for the performance of the contract itself. And let's say you want something to be delivered to your home. So location in this sense would be the necessary data for the performance of the contract. And once you withdraw that data, that would eventually actually lead to a situation because you have the right to withdraw the consent. And then is it termination, or is there still a way to further pursue the contract? So two situations I came across actually here. When the data subject withdraws his or her consent, the processing stops. But let's think about a situation in which that doesn't terminate the contract. In such a case, can the service provider ask the performance and try to force the data subject to provide his or her data? It's not possible under the GDPR. Then can the service provider claims damages for non-performance based on the contract? In this case, I think if the personal data, if it's not necessary for the contract, and instead of claiming the damages for non-performance, I think it makes more sense to give the right to terminate the contract to the service provider, because this is I think it's a gap the regulation, because if you withdraw your consent, you actually prevent the collection of the personal data. But in other words, the service provider under the obligation to provide the service. Therefore, instead of claiming the damages, I think it makes more sense to give the service provider the right to terminate the contract. This is how I would think about this issue actually. But thank you very much for the question. It's very nice.
Thanks a lot. There's no more questions in the chat, and I see that we're almost at time. Maybe I have one little question, or rather a comment as well, relating to a question that I'm often encountering. Increasingly, you see big tech platforms rely on necessity for performance of a contract, so the second lawful ground, rather than consent, rather than legitimate interest, although that's also quite popular. But at least like consent is really like less and less relied upon. And as many of these online platforms that we use, you know, for entertainment, in education, for dating, whatever, they rely on recommender systems. And these recommender systems, they are, of course, informed by a lot of personal data signals, from your basic demographics to your browsing history to whatever, right? That determines what you see in your Facebook newsfeed, etc. Now, to what extent can these companies rely on the second lawful ground for this personalization purpose? I think it's quite an interesting and hard question, and important practically, because it is quite a strong lawful ground and it is very hard to challenge as a data subject. You barely have any data rights available when that is the lawful ground. And it ties to your research, because in order to assess the validity of relying on that second lawful ground, you will have to then go to the contract, the terms of service, which is, of course, very asymmetric and non-negotiable, really. I think that's an area where your insights would be quite valuable as well, to see to what extent this Article 6.1b in the GDPR interacts then with being able to challenge this all or nothing approach in terms of services. I mean, I'm not expecting you to necessarily like give an answer, but we can pick up this discussion.
Thank you very much for the comment. Actually, I will definitely do more research on this part of the comparison.
Thomas, you wanted to say something?
Just as a quick, I mean, I think it's a very super interesting question. I think I would be especially interested because, I mean, the key is going to be, well, do I expect a personalized service or not? And I would expect the answer to be very different for a dating app like Tinder, where I'm kind of expecting that to profile me. So they give me matches that meet my personality, versus Facebook, where I don't really care about getting personalized ads. So I think maybe the very nature of the service might have an impact there. I think the answer to be different in those two scenarios.
All right, and on that happy note, I think I'm gonna close this session so people have time to move through Gather Town to the final closing session by Paul de Hert. Thank you both to the speakers and the audience for sitting through this very last session at the end of CPDP 2021. And I hope to see you guys soon at maybe CPDP 2022 or at another conference, hopefully live someday.
Thank you. Bye.
Bye.